My name is Lewis Taylor. I'm an attorney at Venable. Venable has offices in D.C., Baltimore, New York, L.A., Northern Virginia, other places. I work in Baltimore. My practice is primarily, well, it's not primarily anything. It's pretty wide-ranging. We do a lot of regulatory compliance work, environmental due diligence, and civil and criminal enforcement at the state and federal level. Today, I'll just give you a little preview of what we're going to do, and then I'll hand it over to Anna. We're going to provide a real kind of 100,000-foot overview of the management and regulation of hazardous waste and the cleanup of hazardous waste sites in the United States. We're going to go chronologically. Anna's going to start with RCRA and talk about how we manage the transport and storage and disposal of hazardous waste. And then I'm going to provide a discussion of CERCLA and talk about what happens when RCRA hasn't worked, or really more legacy sites from before RCRA was enacted, and how we clean up hazardous waste sites and who gets to pay for that. So thanks for joining us, whether you're here and are on the phone, or if you're unfortunate enough to have enough time on your hands to be watching this video at some point in the future. I will hand it over to Anna.
Okay. Hi, everyone. My name is Anna Cooperstein, and I am an attorney with Keller and Heckman. My practice focuses mostly on chemicals regulation, so I do chemicals under TSCA, pesticides under FIFRA, both in the U.S. on the state and federal level, as well as abroad. We get a lot of questions about Europe and REACH, compliance in Canada, countries in South America, so all over the place, really. And like Lewis said, really our goal today is to provide you with a very general, basic, good overview of RCRA and CERCLA, where they came from, what they do, how they work. And so I know that ELI is doing a whole summer series on environmental statutes, environmental law. So you'll be covering all the other statutes in other sessions, but I did want to just do a brief overview of an era where a lot of environmental statutes were issued, promulgated, before we dive headfirst into RCRA specifically. So here we just have a list of major environmental laws and when they were enacted, chronological list. And as you can see, in the 70s, there was this really tremendous surge in environmental law in the U.S. A lot of major laws that implemented quite substantial changes in the U.S. were enacted within about 7 years. And RCRA and CERCLA were part of that trend. And I think this kind of very dramatic overhaul would be pretty unlikely in any area of law today. And part of the reason that so many environmental laws were enacted in such quick succession, one right after the other, is that people really started getting worried, really seriously worried about the state of the environment, and not just the environment sort of outside there, but also its impact on us as human beings, on our public health and our safety. So really for RCRA, RCRA originated because people were worried about trash. That's point zero for RCRA. And trash really isn't a new problem. Archaeologists uncovered various systems of waste management all around the world. For example, in 500 BC, the Greeks developed one of the first municipal disposal sites in the Western world. And what they did was they required people living in Athens to take their trash and dispose of it at least 1 mile outside of the city. So sort of that first major push to get the trash out of where we're living and working and eating to somewhere else. And then around 200 AD, the Romans created a system for actually collecting the garbage, where men would actually walk around the city and pick up garbage, load it onto a wagon, so then it could be transported elsewhere. So again, implementing this system of taking all this trash that we're generating and putting it somewhere else outside of where we're living and working. So of course, when the industrial era started in the 1700s, it really exacerbated the waste problem. The population of cities was just exploding, and there was a lot more human-generated waste per square foot in these cities. At the same time, trash and waste were just being dumped right onto the city streets. So if you could imagine, you're making dinner, you've got eggshells and chicken bones and all that stuff, and you just toss it right outside your window. And there it is for everyone to enjoy as they pass by. So in addition to this sort of traditional household normal waste, there was also a lot more industrial activities. So we have a lot more factories and mills and mines. And that waste was generally just being dumped into rivers and waterways. So people really weren't thinking about what the impact of all this waste was. It was more of this attitude of out of sight, out of mind. And what really inspired people to start taking trash and waste seriously was growing evidence that our trash and waste was causing public health problems. So in the 1800s, there were several cholera outbreaks in England because sewage was coming into contact with drinking water and contaminating it. And we're not going to talk about sewage too much in this presentation, but I think ELI puts on a boot camp every year, and when I went to the boot camp 3 years ago, there was a guy there who talked about sewage regulation, and he called himself a poop lawyer, and it was just the most fascinating presentation I've ever seen in my life. So if you ever meet a poop lawyer, take the opportunity to grill them about what they do.
I'm a poop lawyer.
Poop lawyer. Again, there were outbreaks of cholera, typhoid, bubonic plague, which was carried by rats, carrying infected fleas. And in the mid-1850s, people really started to determine that there was a link between unsanitary conditions and all these diseases that were prevalent at the time. And initially, they thought that these diseases were actually caused by foul or noxious air coming from garbage and sewers. And this was known as the miasma theory. And there was also a sanitation theory, which hypothesized that filth contributed to disease. So people were getting closer and closer to the truth of the matter, which is that it's these microorganisms in all this stuff that cause disease. But again, there's this growing recognition that we're not sure exactly how it works, we're not sure exactly why this waste is bad for us, but we know that it's causing problems. People started developing new ways of disposing trash. And so, for example, in the late 1800s, there were several cities in the U.S. that built incinerators to burn their trash. So this whole industrial trend continued into the 20th century. Cities continue to grow, industry is expanding, and more trash is being generated. And at the time, there were a lot of innovations in material science and engineering that contributed to this waste. A lot more materials were being invented that were much cheaper and better for consumers. Products would cost less. But unfortunately, a lot of these products were disposable. So things like paper towels, cellophane, wax paper, aluminum foil, and new types of plastic, they all made shipping and consuming and providing articles to consumers a lot easier, but it was all designed to be thrown away. Styrofoam, beer cans, nylon, paperback books, TV dinners, disposable razors, and all this helped to continue to fill up our ever-growing landfills. And one point to mention is that when RCRA was enacted, it was 1976, and we already had endpoint regulation through the Clean Air and Water Act. So we were already regulating what was going into the air, what was going into the water, and RCRA is all about what goes into the ground, but we weren't really thinking about that. So in terms of the legislative history, RCRA's predecessor is the Solid Waste Disposal Act, and it was enacted in 1965, and it was actually a pretty modest statute, not nearly as far-reaching as RCRA would become. And it really just created a program for researching how solid waste was managed in the U.S. There's some pretty scary statistics of amount of solid waste being generated at the time. 3 to 4 billion tons of solid waste per year, growing at an annual rate of 8%. So in addition to all this normal solid waste, there wasn't also special treatment for hazardous waste. It was disposed of in landfills right along with all the normal household trash that we talked about. There was no record keeping to make sure we knew which landfills had hazardous waste. And as a result, they could be transferred from one owner to another. People could buy and sell, transfer ownership of landfills without people really understanding what was there. And because hazardous materials were just disposed of willy-nilly, just like normal waste, it began seeping into the ground and contaminating water. And between the 40s and 60s, scientists and engineers really started developing a lot of empirical knowledge about hazardous properties of this hazardous waste, and how it was actually transported by groundwater through soil and rock. So it would migrate from these landfill facilities. So RCRA was enacted in 1976 and intended to address both regular solid waste as well as that industrial hazardous waste. And according to legislative history, it was described as designed to eliminate the last remaining loophole in environmental law, that of unregulated land disposal of discarded materials and hazardous wastes. And I think it's kind of precious that people thought at the time that like RCRA was the end all be all. It was gonna like close out all the environmental problems. We got it. We can sort of put up our hands and sit back and relax. But that was the thought at the time. This is just a slide about additional legislative history, additional amendments to RCRA. We're not going to go through this in detail. This is just for purposes of reference. If for some reason you feel a burning desire to learn more about RCRA's legislative history. So now that we've talked about the problems that really not originated, but precipitated RCRA. Let's just talk about briefly what the goals of RCRA are. So goal number 1 is to protect human health and the environment. So again, we're really concerned about the impact of hazardous waste on groundwater. And in terms of its goals, RCRA implemented certain design requirements for disposal of hazardous and non-hazardous waste in terms of the kind of liners you had to have, or groundwater monitoring. We'll talk about that later. And also, RCRA isn't just about making that throwing away process safe, making disposal safe. It's also about reduce, reuse, and recycle, which is a phrase that I'm sure all of us grew up with. Congress did find that a lot of materials that were being thrown out could actually be reused and repurposed. So RCRA does encourage also changing industrial processes to reduce the waste that's created. Since we're going to talk about both RCRA and CERCLA today, I just wanted to take a brief moment to distinguish the two for you in a very broad way. So RCRA, as Lewis said, is all about what happens before. RCRA is a preventative statute. It's intended to control the transport and the movement of waste in order to prevent contamination. And RCRA does that through regulatory means. CERCLA is all about what happens after. So a spill has already occurred. A spill had occurred in the past. What are we going to do to clean it up? Who's going to pay for it? Which becomes a very important issue as well. So now let's get right into RCRA itself. And today I just want to highlight 3 major components of the statute. Subtitle C, which deals with hazardous waste. And as we will discuss, this subtitle established a very comprehensive tracking system for hazardous waste, from cradle to grave, and implements very specific standards for those who generate hazardous waste, those who transport and ship hazardous waste, and finally those facilities that are the final resting place that are going to treat the hazardous waste or store it. Subtitle D deals with non-hazardous waste, and this really focuses on empowering the states to deal with municipal solid waste landfills, so it's more of a state-run program. And then we'll touch a little bit on Subtitle I, which deals with underground storage tanks. So again, the focus is on protecting our groundwater and making sure hazardous stuff, hazardous substances that are in these tanks don't end up leaking into the soil and water and contaminating it. So for Subtitle C, again, the purpose of this part is to regulate hazardous waste from cradle to grave, from the moment it's generated to the final point where it's disposed of, it's buried, it can rest in peace. So in terms of the specific requirements, Subtitle C places responsibility on generators, transporters and facilities that treat, store, and dispose of hazardous waste. And one of the ways that this tracking program is implemented, it's really primarily through the hazardous waste manifest system. It's a system of forms, reports, and procedures that track hazardous waste from the time it leaves the generator facility until it reaches the waste management facility. So each entity along the way, every person who touches the hazardous waste has to sign the manifest, and this is all done to ensure that the entire thing is transported safely from beginning to end. We don't want any lost along the highway in a random ditch somewhere. We want to make sure that it's all transported properly to the final resting place. So since we're talking about this manifest system, I just wanted to show you an example of the hazardous waste manifest form. And because this is an 8x11 sheet, I just broke it up into the top half and bottom half. So on the top half, you'll see that there's information for the generator to fill out. You've got the generator's name, mailing address, contact information, the generator's ID, which we'll talk about later. The generator also has to indicate who's going to be transporting it. We want to know exactly who's going to be responsible for shipping the waste from point A to point B. And then we have a big section for the generator to describe exactly what is being transported. So for example, they have to include a very specific description, including the proper shipping name for the waste, its hazard class, and its ID number. Also the number of containers and what type of containers we're expecting. And then the weight or volume, again, to make sure we don't lose any hazardous waste along the way. And then at the bottom, we just have one little piece for any special handling instructions that they might want to add. And then at the next slide, it's the bottom portion of the form where the transporter acknowledges that they received the materials. Below that, we have a form space for the designated facility. That's the treatment facility, the final resting place. And you'll see in at the beginning of the designated facility portion, there are a couple slots for discrepancy. So this is where they're going to match up the top half of the hazardous manifest to what they actually received. They want to make sure that they received exactly what they were supposed to. And you'll notice that in the discrepancy portion, there's actually spots for partial rejection or full rejection. So a facility can actually reject hazardous waste that is delivered to it if it doesn't meet the specifications outlined above. So in terms of the responsibilities for these three classes of people, a generator of hazardous waste, first of all, what form does it take? So a generator can be a dry cleaner, a car repair shop, can be a hospital or a photo processor, and of course chemical manufacturers and petroleum refineries, more heavy-duty industries. In terms of their responsibilities, they have to get a government-issued ID. They have to determine if their wastes are hazardous, so they can't just sort of willy-nilly throw things away that they're not sure what the properties are. They actually have to make sure they understand what the properties of the hazardous waste are. They have to store and handle the waste properly before it's shipped off. They do have to notify transporters that the waste is hazardous. They can't just put it in a box and ship it off in UPS and hope it arrives at the right place. They actually have to tell people you're dealing with stuff here that's very toxic or corrosive, whatever the case may be. They do have to, again, prepare the manifest form and track the shipment of the waste. They also have to keep records of the test results and any analyses they do. And there are actually limits on how long generators can store hazardous waste on their facilities. And it depends on how much hazardous waste in total they generate every month. So, so there's a group that is called under RCRA conditionally exempt small quantity generators. And these are facilities that generate less than 200 pounds of waste per month. These facilities do not have a time limit on storing the hazardous waste, and they're actually exempt under the statute from most of the requirements from generators. They do have to manage their waste in a responsible way that meets the guidelines, but a lot of the other requirements don't apply to them because it's just such a small amount of hazardous waste. Then we have small quantity generators that generate somewhere between 200 and 2,200 pounds per month, and they're actually allowed to store their waste on site for up to 180 days, so 6 months. And then large quantity generators, these are the big mamas. Any facility that generates more than 2,200 pounds per month of hazardous waste, they're limited to 90 days. So after about 3 months, they have to ship off the hazardous waste. For transporters, you'll see, this is going to start to sound familiar. They have to get a government-issued ID. They have to label their shipments as hazardous waste and handle it properly. They also have to transport the hazardous waste to a licensed treatment facility and deliver that manifest form, signed and dated, to the treatment facility. Transporters also have an important obligation with respect to any accidents that arise. If there's a spill along the way, like I said, we're driving up 95. Lewis and I have a transporter business. That's what we do. We quit law forever, and we went into business transporting hazardous waste because we thought it would be so profitable. And if we're driving along and we notice that there's something suspicious leaking out of the back of the truck, we can't just go on our merry way leaking hazardous waste up 995. We have to take corrective action to protect human health and the environment.
Which we do immediately.
Of course. Our hazardous waste transporter company would live up to the highest standards of treatment. Absolutely. And then in terms of the treatment facility, again, you've got to have a government-issued permit. Let's say that Lewis and I decided that the transporting business is too competitive, and instead we're going to open up a facility. Well, we can't just rent out an apartment and say, all right, this is a treatment, storage, and disposal facility for hazardous waste. We will keep your waste for a sizable fee, and you just leave it here and don't worry about it. We actually have to apply for a permit and make sure that we're approved. We would have to store, treat, and dispose of waste in units that meet very specific design criteria. In terms of that manifest form, once the manifest reaches the treatment facility, it actually has to circle back and go back to the original generator. So that sort of closes the loop on the great journey of hazardous waste, so that the generator knows at the end that it did actually get to where it was supposed to be. For a facility to operate and store hazardous waste, you actually have to demonstrate financial capacity to take corrective action in case of a leak. So that just means that you've got to have money in the bank. You've got to make sure that if a spill occurs, you must be able to prove that you're going to be able to pay to clean it up. Of course, if there's a spill or a release of hazardous waste, you have to take corrective action. And you also have to conduct groundwater monitoring. Again, repeating this several times over, the emphasis here is on protecting water, protecting soil. So if you're going to store hazardous waste on your site, you better make sure that you have a water monitoring system in place. So I just wanted to show you an example of the type of design requirements that you can expect for hazardous waste. These are just some examples, some cross-sections of various means of storing hazardous waste. The top one is a tank, and you see that in the middle is your hazardous waste tank that holds everything in. And you also have a secondary containment system. It's just an outer wall. That's your plan B. It's your backup in case something happens to the containment system, it ruptures, you want to have a backup plan in place. And at the bottom, we have a surface impoundment, and that big, giant gray rectangle is actually earth right there, even though it looks like a block. So you've got your soil, then you have 2 levels of liners with a removal system in between to collect anything that's going to leak past the first liner. So again, you've got your first system of protection, and then plan B, your backup system. And here you even have a plan C. It's like triple backup for hazardous waste. And your plan C is that groundwater monitoring well on the left. So that's going to catch, it's intended to catch any hazardous waste that makes it past the first liner and the second liner. So now that we've spent all this time talking about managing hazardous waste and transporting hazardous waste, it might be useful to actually talk about what is hazardous waste, what qualifies as hazardous waste. So the first test is that hazardous waste has to be a solid waste. It can be garbage, refuge, sludge, or other discarded material. And, you know, what's great about the law is that a term doesn't always mean what it sounds like. So a solid waste can be a solid, it can be a semi-solid, it can be a liquid, and it can be gaseous material. So a solid can be a liquid. That's what I love about the law. A solid can be a liquid.
That's why we need lawyers.
That's right. In terms of the types of hazardous waste, there are a couple in the statute. There are listed wastes that are specific substances that EPA has determined are per se hazardous. So, for example, wastes from wood preserving or other types of industrial processes are listed as hazardous wastes. Then we have wastes that are characteristic wastes. These are substances that aren't listed and identified specifically by the industry that they're coming from, but they have one of these four properties. They're either ignitable, corrosive, reactive, or toxic. So if your substance has one of those four properties, then it's going to be deemed hazardous waste for purposes of RCRA. Also, contaminated media is considered hazardous waste. So for example, we have some hazardous waste, some liquid solid waste that leaks into soil. Now that that soil has been contaminated, it's also considered a hazardous waste. And then there are a few special provisions for used oil and universal wastes, which apply to things like batteries, pesticides, and equipment containing mercury. So next, let's move on to non-hazardous waste, which is regulated under Subtitle D. And in terms of, what is non-hazardous waste compared to hazardous waste, we're talking about municipal solid waste, which is a lot of this sort of household trash that you think of. Household appliances, metal scrap, empty containers. It can also be industrial waste as long as it's not hazardous, depending on the criteria we just talked about. It can be sludge and other types of waste, so there's a statutory definition and regulatory requirements for non-hazardous waste. So as I mentioned earlier, non-hazardous waste is regulated primarily through a state-run permitting system. It encourages reducing disposed waste through recycling or composting or even combustion. And facilities have to implement public health and safety precautions. Again, our focus on protecting water and preventing disease. And so it's really states that have the primary responsibility under Subtitle D. And in terms of the design requirements, here's another cross-section for you to see what a solid waste landfill looks like. So next time you are making that trip out to a solid waste landfill to dump your TV or something like that, you can actually imagine in your mind's eye this cross-section of what it looks like underneath the ground. So again, it's similar type of design. We have a leachate collection system, a liner as well, and then a system for monitoring the groundwater too. There's also a system for monitoring explosive gases, because especially in landfills there tend to be a lot of methane generated, so sometimes you get things that explode or erupt in a fire. So that's well as intended to monitor the presence of any of those explosive gases. So in terms of other responsibilities under RCRA, treatment facilities do have to perform corrective action if there's a leak or if there's a spill. And under RCRA, you can't always just walk away from your treatment facility. You have to make sure that either you close it out clean, you get this clean closure, which means all the waste has been removed. If you don't have clean closure, if you can't remove all the waste, you have to continue monitoring to make sure that there's no contamination later on. So I thought I would talk about this one hot topic for purposes of hazardous or non-hazardous wastes. And it's all about coal ash, or CCR, coal combustion residuals. So coal ash is released from power plants that burn coal, and it's often mixed with water in order to contain it, because coal ash is, it's going to fly around everywhere. When it's mixed with water, it's in a little bit more of a stable state. And CCR is actually considered a quote-unquote special waste that's under RCRA, exempt from regulation as a hazardous waste, until EPA conducts a risk assessment and reports to Congress about it. Well, EPA has actually complied with this requirement and issued several reports concluding that coal ash is not a hazardous waste. We don't want to regulate it under Subtitle C. In terms of the numbers for coal ash, just a few years ago in 2008, there were more than 136 million tons of coal ash generated per year. And 75% of it was stored in impoundments that are more than 25 years old, and 10% are stored in locations more than 50 years old. So in terms of the storage capacity and the storage abilities, we're talking about facilities that are quite old and not up to date. This issue came to a head in 2008 when at the Kingston fossil plant in Tennessee, there was a rupture and there was a huge spill of coal ash slurry. They were actually storing this coal ash slurry in a 40-acre unlined pond that was above ground. So remember, we looked at all these cross-sections that have these protective measures in place. You have 1 line or 2 line or groundwater monitoring. Well, this was stored in a pond that was totally unlined. And in December of 2008, one of the walls holding in all the sludge actually ruptured and released over 1 billion gallons of sludge into the surrounding area. And it's about the size of 1,600 Olympic-sized swimming pools, just for reference. The spill covered 300 acres. It destroyed numerous homes. It downed power lines, gas lines, and it killed fish as well. Let's not forget the fish, the environment. And the cleanup was estimated to cost $1 billion. So, pretty big deal. And here is just an overhead view of the ash slide. So in the before picture on the left, you can see that central section. It's almost like, it's almost a rectangle shape where all the sludge was contained. And then in the after picture, you can see that it was that northeast wall that ruptured. And all of that blue stuff that's going out to the left and to the center and to the right, that's all coal ash slurry. So just to give you an idea of what that looked like in the surrounding area, those are roofs of homes that you see poking out. So you can imagine that their property value was affected a little bit. Just a couple more pictures of what it looked like with all the sludge in the surrounding area. And the cleanup effort. Wouldn't you like to be that guy or girl? So needless to say, people were outraged, very upset. How could you be storing all this coal ash in an unlined pond? How could this have happened? And so EPA determined to take action. And they proposed a rule just last year to regulate coal ash under RCRA. In terms of the scientific basis, since we're talking about the hazardous properties, how do we know it's a hazardous waste? The contaminants of concern in coal ash are several metals, antimony, arsenic, barium, beryllium, cadmium, chromium, lead, mercury, nickel, selenium, silver, and thallium. And even though EP determined that these metals weren't at critical levels in the coal ash slurry, the problem was because the typical disposal units were so large, they were really afraid that the metals would leach into the ground at high levels of concern. So EPA proposed 2 options for regulating coal ash, either as a special waste under Subtitle C or as a non-hazardous waste under Subtitle D. So option 1 would have EPA regulating coal ash as a special waste under Subtitle C. So so this whole time we've been talking about Subtitle C is regulating hazardous waste. But EPA proposed not calling coal ash a hazardous waste because that might stigmatize it. So they want to encourage recycling of the coal ash, and they were afraid that if we call it hazardous waste, nobody's going to want to touch it, and that will reduce the likelihood of it being recycled and reused. So we're going to call it a special waste. But it would still be regulated under Subtitle C, which is that whole cradle-to-grave system, from generation to disposal. It would require installing liners and leachate collection systems at landfills and surface impoundments. And surface impoundments would also have to manage any fugitive dust. And then this option would also phase out the wet storage of coal ash within 5 years. The second option is the non-hazardous option under Subtitle D. So under this provision, only the disposal of coal ash slurry would be regulated. It isn't that same cradle-to-grave system that we have under Subtitle C. EPA would implement some national standards for landfills and surface impoundments where coal ash was going to be stored. Any new landfills would be required to install that liner and leachate collection system. And any existing landfills, if they were going to be converted to store coal ash or store coal ash currently, they would actually be required to meet the new safety requirements, or they would have to be phased out. And under this option, EPA would allow wet handling of coal ash. And this is just another, just so you can see side by side the comparison between Subtitle C and D. It's a really good case study for understanding what are the differences between regulation under the two parts of RCRA. All right, so actually I lied a little bit. There's actually an option 3, but it's only because EPA snuck it on us as well. So option 3 is regulating coal ash as a non-hazardous waste under Subtitle D prime. Okay, so there's no such thing as D prime, but here's the idea. It's the same as Subtitle D, except that it would grandfather in existing surface impoundments for storing coal ash. So they could just operate for the rest of their natural lives without installing any of that protective liner or any of that leachate collection system. So it was a very, I want to say popular rule, but what I probably mean is contentious rule, because EPA received almost 500,000 comments, which is huge. EPA Administrator Jackson first estimated that maybe they would issue the final rule in 2012. Now it's sort of being pushed back to 2013. We'll see how that goes. And just earlier this year, EPA said that it was going to hold another public comment period to consider new data and new risk-benefit and cost-benefit analyses. So while all this regulatory stuff is going on, there are also legislative proposals to regulate coal ash. 2 bills are currently being considered. HR 1391 would exempt all of these types of coal ash from regulation as hazardous waste under RCRA, so it would preempt EPA from regulating coal ash under Subtitle C. And there's also another bill that was introduced to authorize state regulation of coal ash, rather than on a federal level by EPA. So this is a hot topic. I think if Lewis and I keep giving this presentation in the next 5 years, it will probably still be going on.
The costs are significant, and it's interesting how RCRA, this issue, really is a significant factor in current energy policy, because you can imagine who's generating coal ash, and the cost of complying with these new rules, depending on what they are, could be very significant. But then, obviously people are a little disturbed about what happened with the Kingston spill.
Should we go back to those pictures, or?
There's some other cases where there's been some very large settlements with some coal ash, disposal sites.
Mm-hmm. Big ticket item. So I just want to close out by talking briefly about underground storage tanks, and these are regulated under Subtitle I. And again, we're talking about drinking water this whole time. We want to protect drinking water from these underground tanks that store petroleum or other hazardous substances. In terms of the technical requirements, again, there are certain design requirements to ensure that these underground tanks safely store hazardous substances. And you have to report any new tanks that are installed, as well as upgrade older ones to make sure they still comply with the current standards. And again, financial requirements, you gotta have money in the bank. If you're gonna own underground storage tanks, you have to demonstrate that if something goes wrong, if there's a spill or release, that you can pay to clean it up. So some underground tanks are regulated under Subtitle I, some are not. The ones that are regulated under Subtitle I, first it has to be a tank that is at least 10% underground. And this is a little misleading because you could have tanks that are totally above ground but connected through underground piping. And if that underground piping constitutes at least 10% of the entire tank system, then it's considered an underground storage tank. And the tank also has to hold either petroleum or hazardous chemicals, which is different from hazardous wastes. If it's a tank that holds hazardous wastes, it's regulated under Subtitle C already. And then there are also some small residential tanks that are not subject to Subtitle I regulation. In terms of enforcement, RCRA is a strict liability statute, and you can also get hit with criminal penalties for knowing violations. So strict liability, you violated the statute, you transported without a permit, but I didn't mean to, or I didn't realize I was doing it. Too bad, so sad. You're still liable. But if you knew that you were transporting without a permit and you knew you should have had one, then you get hit with criminal penalties. The civil penalties can be up to $37,500 per day, and the criminal penalties can be up to $50,000 per day and up to 5 years in prison. So, it's a big investment to make sure you do things right if you're going to be in the business of managing hazardous waste. And in addition to these monetary and criminal penalties, EPA can also require facilities to do additional monitoring analysis, and then of course, if there's imminent danger to human health or the environment, then EPA can order a facility to take corrective action. So just briefly, in terms of importing and exporting hazardous waste, while EPA has a robust system for managing hazardous waste, it's not always the same around the world. So in terms of shipping hazardous waste from place to place, you want to look to the Basel Convention. U.S. is only a signatory, hasn't ratified it. So in terms of shipping waste between U.S. and parties to the convention, you have to have a special agreement in place. And then finally, just to wrap up, in terms of, what are the benefits of RCRA? What are the final results of RCRA? Just two numbers for you to hold on to. In 1960, almost 94% of solid waste was thrown away into landfills or other disposal. But in 2007, this was down to only 54%. So RCRA, maybe RCRA can't take all the credit, but for purposes of today, we're going to say that it resulted in, essentially having the amount of solid waste in landfills. Even though it's still a huge problem today, I think it went a long way towards management of hazardous waste and also minimizing generated solid waste. A couple of resources for you guys in case you want to do more investigation. And that's it for my half.
Thank you. Our plan is to take questions at the end. We should have a question and comment period at the end. And while we're getting set up with my presentation, we didn't really respond to Rebecca's question about our backgrounds. Anna and I both went to the University of Maryland School of Law, which has, in my opinion, the best environmental law program in the country. I'm sure we might get a little debate about that.
In our unbiased opinion, of course.
I know we've got some Vermont grads, I think, or Vermont students in the room. Were there any Lewis and Clark students in the room? No. Okay, so if anybody, just by a show of hands here in the room, who is either a law student or an attorney? just by a show of hands. And who is more on the science side of things, or policy? Okay, so the attorneys heavily outweigh the science folks, which is good, because our focus today is, let's see if I can do this without breaking anything, is the legal side of things. Well, we've ended the, did you want to say anything about your background?
Background, should we talk about career experience that led us to where we are today?
That's a long story.
No, it's not a long story. I'll be brief. I went to law school straight from undergrad at MIT, and then during law school I interned at NRDC, just down the street, and then the World Health Organization, and then joined Keller and Heckman upon graduating from law school.
And I have a undergraduate degree in film and television from New York University, and a master's degree in anthropology, and went to law school a little bit later in life. One of the great things about Maryland, I'll say, is because it's located proximate to Washington, D.C., the internship opportunities are great. You worked at NRDC.
Mm-hmm.
I had the opportunity to work at the Department of Justice in the Environmental and Natural Resources Division, where I kind of got my first taste of actual CERCLA practice, and was also able to intern in the U.S. Senate on the Environment and Public Works Committee staff. And then we both have gone into private practice,
Mm-hmm.
which is its own story that we won't get into today. So the calm and measured portion of our program has ended. Welcome to my portion of the program. If just to make a little analogy, if Anna's presentation was "It's a Small World" ride at Disney World, now we're getting on Mr. Toad's Wild Ride. And that is partly because CERCLA is a complex, ambiguous statute that has had an enormous amount of litigation attendant to it, which is fortunate for environmental attorneys. It has sent many, many children of environmental attorneys to college and on to European vacations and whatnot. So I'm really I have a lot of slides, and there's a lot of things we could go into, but I'm just going to try and drag you through the high spots as quickly as I can. The CERCLA is really not so much a regulatory statute as the Clean Water Act, the Clean Air Act, and RCRA are. It is more a framework for allocating liability and paying for the cleanup of sites that have been contaminated by hazardous wastes. There are some reporting provisions in CERCLA. Once there's been a spill, there are certain requirements for timely reporting, and those, I'll touch on those briefly. Those have civil and criminal liability attached to them. But really, CERCLA is about cleaning up sites. So it authorizes the federal government to go in and take different actions to clean up sites, and it creates provisions to recover costs associated with cleaning up those sites, whether it is costs that have been expended by the federal or state governments or costs that have been expended by private parties. So here's some CERCLA highlights. The CERCLA is often known as the Superfund, which is a bit of a misnomer today because the Superfund was a tax that was created initially with CERCLA. Petroleum and chemical companies were taxed, and that money went into a fund that was going to be used to pay to clean up sites. The fund still exists, but the taxes are no longer in play. There's some legislative proposals to bring those taxes back in, but there are occasional congressional appropriations to clean up sites, but the Superfund is really not as big of a part of CERCLA today as it once was. Really, for me, one of the big takeaways from CERCLA is the liability scheme and the kind of liability it imposes on folks that have acted in accordance with the law. So, and last year I think we did an example of a shoe company. There are many companies, any major American company is tied up with CERCLA sites. Any major American city is tied up with CERCLA sites. I know we've got some DC Department of Environment folks here today. Anybody working on anything with the CERCLA site? one guy is. So urban centers have major problems with CERCLA sites, brownfield sites that are contaminated. So in figuring out how to pay for this, Congress enacted a joint and several liability scheme. If you sent your waste to a landfill that was properly licensed in accordance with existing regulations in 1970, and there's a problem today, you're going to pay. The decision was who pays, the U.S. taxpayer or the person who in some sense benefited from the disposal of the materials that are now causing a problem. So I'm going to move on because I can just digress and digress about Superfund. 1 in 4 Americans live within 3 miles of a Superfund site. And we're going to have a map later that shows some national priority list sites, which are the big CERCLA sites, and you'll see that the Northeast Corridor is loaded with them. So this is a major problem created, along the lines of what Anna talked about, initially with the advent of industrial production and massive, steel making and other manufacturing operations. Those operations create a lot of waste, and initially the understanding wasn't there about what types of problems could arise if those wastes weren't handled properly. So mining and heavy industry are often industries that are connected with CERCLA sites. Another one is dry cleaning sites. These are often contributors to local, to urban, rather, problem sites. The graphic on the bottom left there is from one of my favorite sources, Wikipedia. It's ancient Roman wall painting, I guess, that depicts dry cleaning operations. According to Wikipedia and some other sites that I've researched, Romans used ammonia derived from urine to clean woolen togas and to keep them white. They also used it for toothpaste. And these sites where this manufacturing, or not manufacturing, but this industry occurred, the creation of ammonia from the source material were hazardous waste sites back in ancient Roman times. Today we use other chemicals that have a remarkable capacity to migrate into groundwater and cause problems. So 1976, we've got RCRA. 1978, there's a big wake-up call with Love Canal, where a chemical company had been operating in an area for a while. They'd been using an abandoned canal to dump wastes. The school board was looking for a place to build a school. The chemical company said, "You do not want to build here?" The school board said, "Yeah, we do." As they built the school, problems became evident, and this was a major precipitating factor for the development of CERCLA. CERCLA is not a model of legislative draftsmanship.
To put it nicely.
To put it nicely, you can see, you often will read, the two things you always see in a CERCLA case are, 1, that it's based on common law principles of liability, and 2, that it's a mess. One way or the other, it's ambiguous and confusing, hopelessly confusing, according to some federal judges. Here's a brief outline of some of the more dominant provisions in the statute. Here's a brief legislative history. Highlights here include 1986 with the SARA amendments and the 2002 Small Business Liability Relief and Brownfields Reauthorization Act. One of the major problems. I'll let you do that. One of the major problems subsequent to the enactment of CERCLA was real estate transactions really slowed down because people were very concerned about acquiring property that was contaminated, because mere ownership of a property that's contaminated can result in financial liability for cleanup costs. So investment in real estate declined significantly, and the 2002 amendments and the 1986 amendments were efforts to try and address those issues, and we'll touch on those very briefly. Initially, when CERCLA was passed, there was a lack of enforcement. Rita Lavelle, who was at EPA, was convicted of contempt of Congress, which I won't go into too much here since I know I'm going to run out of time at the end, and Gorsuch resigned. There was basically not the kind of action taken to address CERCLA sites that Congress wanted. And I'll let you review. There's plenty of material in these slides to review on your own if you're interested in more information. At EPA, the Office of Solid Waste and Emergency Response is the primary entity responsible for managing and addressing CERCLA sites. Once a site has kind of been identified and potential defendants or potentially reliable are responsible parties, PRPs, are identified, OECA and Department of Justice take the lead in actually suing entities and recovering funds. When I was at DOJ in the summer of 2000, CERCLA getting money back from U.S. expenditures to clean up CERCLA sites was a major major project for all of the groups, or all of the regions, I should say. The National Contingency Plan. This is a plan that was put in place to address major spills. Who takes charge? Who has authority? The U.S. Coast Guard plays a big role in this for maritime spills, such as the Exxon Valdez disaster. The National Contingency Plan is important if you are a party who's involved in a CERCLA site, because the only costs that are recoverable are costs that were spent consistently with the National Contingency Plan. Some courts used to require that meant you had to have government involvement. That's less the case these days. But you could spend money cleaning up a site not to the standards or the framework of the NCP, and you would not be able to recover those costs from other potentially responsible parties. So before we delve a little bit more into the liability framework, 103 is the provision of CERCLA that requires reporting releases. Any type of release of a hazardous substance, which we'll get to what that means in a minute. It basically means whatever RCRA says it means. Must be reported unless it's been federally permitted, and there's a lot of litigation about what exactly federally permitted means. The spill, in order to be reportable, must be of a certain quantity, which is referred to as a reportable quantity. If you fail to immediately, the statute states, notify the appropriate agency as soon as you have knowledge, you are subject to criminal penalties. There's another issue about who in a company, let's say, is subject to that provision, but it's relatively broad. If you submit false information, that's a bad thing. Under any environmental statute, Rebecca, do you do a section on environmental crimes at all?
For boot camp, no.
For boot camp? There's an ALIABA. My firm has put on an environmental crimes seminar that ALIABA, which is the American Bar Association and American Law Institute, regularly, and I think there's one coming up in maybe October. So if you're a law student, or you can often get free access to ALIABA events, which I recommend. I went to some when I was in law school. If you write to them in advance, you can get a scholarship, and they're very informative. They go, obviously, into a lot more detail than what we're doing here today. But my point being that under any environmental statute, if you make false statements, you are subject to criminal penalties under, 18 U.S.C. 1001, I think. So if you're ever advising clients about what they're going to be reporting to an agency, make sure they tell the truth. The picture here is a methamphetamine lab. This provision, 103, has been used recently to prosecute under a variety of different charges. folks that have run these types of labs. This one, it looks like it's been in an old school. The case that's cited here is actually a case where the court threw out a sentencing enhancement for toxic emissions because the government had not actually entered evidence as to the toxic emissions. So we're going to talk a little bit about cleanup and how it works. Once a site's been identified that it needs to be cleaned up, you can either call Boomer or you can call EPA. When EPA identifies a site, it has a variety of options. It can negotiate with the PRP. It can sue a PRP. It can just clean up the site and then worry about that stuff later, or it can issue administrative orders directing PRPs, potentially responsible parties, to begin cleanup. There's also a citizen supervision that allows citizens in certain cases to take action to help get cleanups going along. The national priorities list is the list of the most significant sites that are most in need of cleanup, that are presenting the greatest risks to public health and the environment. This can be a very contentious process. If you are a PRP at a site that's being looked at for being listed on the NPL or not, you don't want to be listed on the NPL for several reasons that we'll touch on. However, it's really only NPL sites that are eligible for Superfund contributions, and there are certain orphan shares provisions where the federal government will not require folks to pay shares of cleaning up a site that a defunct company owes. That the orphan shares policy is only directly applicable to NPL sites, although there are certain conditions that can make it applicable to non-NPL sites. So there's only 1,200 active NPL sites. It's hard to say how many contaminated waste sites there are in the United States. There's estimates of 500,000 brownfield sites. Not all of those sites are necessarily sites that we're going to require cleanup or remediation, but they are contaminated in some sense. A hot issue here regarding how you get listed as an NPL site is vapor intrusion. The scientists that are going to be involved in assessing the risks and exposure pathways at a CERCLA site will look at water, soil, and air. A new issue that has been in play for a while now and has been proposed as a new pathway for hazardous ranking system is vapor intrusion, which is you have a site that has been contaminated with petroleum products. So there's volatile organic compounds that come through, are emitted through the soil and into the air. If you have a residential structure, those airborne emissions can actually come up into the house and can be somewhat contained in the house. So you can have exposure to airborne emissions through seepage, if you will, of volatile organic compounds through contaminated soil into a residential structure. EPA obviously considers this issue when determining the level of cleanup at a site, but it's thinking about incorporating it in the hazard ranking system. So here's a map from 2010 of NPL sites, and you can see the large number of sites in the Northeast Corridor. There's two types of removal actions, or cleanup actions rather, excuse me. Removal, which is, it's not uncommon for someone to report a site and no one's really been using a site for 10 or 15 years, but there's 155-gallon drums out there full of who knows what. EPA will go out and remove that material, and that may be all that needs to be done at that site. The soil may not be contaminated. There may not be any issues of groundwater contamination. So that would be a removal action. Under a remediation, which is where most of the meat of CERCLA is in terms of getting folks to pay for stuff. Those can be incredibly sophisticated projects. Old landfills that had all kinds of stuff dumped in them, from municipal, solid waste, household trash, to the waste of industrial facilities, can require significant cleanup, from soil excavation to groundwater, on-site groundwater remediation systems. So that's what remediation is. Remediation is a process that attorneys that are working on CERCLA are going to be involved with. Typically, it'll begin with an awareness that a site that someone was associated with might be being investigated, but then you'll get a letter from EPA saying, please send us all your information regarding any waste you may have sent to this site. And it's not just landfills. A case I worked on at DOJ involved a major American corporation that shipped a material to a facility that was supposed to be reusing the material. It was actually spent sulfuric acid. The company used the sulfuric acid, sent it to another company that was supposed to be reusing it. There was leakage along the way at some train stations and at the ultimate destination site. Theoretically, under useful products defense, if you're it's not a waste, so if you're sending a product to another company, you're not liable under CERCLA, but DOJ has certain opinions about what's actually a useful product and what's not. So you get a letter that says, send us all your information. And then this is the framework of how EPA goes about cleaning up a site. What's not included here is the multiple stages of legal negotiation about whether you're going to enter into administrative order of consent to pay for a remedial investigation, et cetera, et cetera. But just to focus on the administrative process in cleaning up a site, EPA will conduct a remedial investigation and a feasibility study where they'll look at the contaminants involved, exposure pathways, different types of risks dependent on who's expected to use the site, whether they're transients, folks, whether they're construction workers, whether it's a residential facility. And that'll produce a big, telephone book of data. And then there'll be a record of decision. The remedial investigation and feasibility study, the feasibility study will say, well, here's some different ways that we could clean up the site. Here's what this is going to cost. Here's what may work well in tandem together. If you do this action for groundwater, you probably don't want to do this for soil. You might want to do this instead. So it'll present options, kind of like under NEPA where you have an alternatives analysis. It'll present options, and then there'll be a record of decision that's made saying, okay, this is what we're going to do to clean up the site. The site, whatever the remedial approach is, will be implemented, and litigation, which may have already been occurring, will ensue. Less today than in years past. In the 80s and into the 90s, the amount of CERCLA litigation was really phenomenal. As most of you probably know, litigation's a lot more expensive today than it was, and there's less litigated, partly because the landscape is a little more certain, although there's plenty of areas of uncertainty, but also because of costs. And companies now budget money that they know they're going to have to spend dealing with cleanup. So it's better for them to get involved with EPA. What you'll often see is a coalition of entities that are potentially responsible coming together and figuring out what a fair allocation is to pay for the cleanup. One of the areas that we're going to get into a little bit that's a result of that is more action against private parties to gain cleanup costs. So a coalition might go after folks that haven't joined the coalition to help pay. So we're going to go a little bit now into the liability framework. As I discussed, Superfund's not really pulling the cart in terms of paying for the cleanup of all these sites. There have been bills introduced in recent years. President Obama, in his 2012 budget, has a Superfund tax in there. Given the current demographics of the House and the Senate, it's unlikely that that's going to pass. Senator Lautenberg's from New Jersey. One of the House bills is sponsored, actually the New Jersey rep might be on both those bills. New Jersey has a lot of historic manufacturing and industrial activity and has a lot of CERCLA sites. So the tax as it was, here's what the tax was, just to give you a sense of who was paying for cleanup. You know, there are some sectors of industry that are happy to have the Superfund tax come back because they're paying for it anyway. So you really got to crunch the numbers, I guess, and look at what's going to work. Some of the bills that are introduced are just reinstating the tax as it was. Others have some modifications. So, CERCLA liability is retroactive, meaning we don't care if you complied with the law in 1970. We have a problem now, and you're liable. You're liable even though you complied with the law, strictly liable. And you're joint and severally liable. What's that mean? Well, when the government brings an enforcement action at a site, let's say there's 3 parties that have contributed to the pollution at that site. Let's say that each party contributed an exactly equal amount of the same substance. So really, from an equitable standpoint, they're each should be liable for 33% of the cleanup costs. But one of those companies is bankrupt, gone, went bankrupt 10 years ago. The other company only has $10. They're on the verge of bankruptcy. The last company gets to pay the whole bill. That's fair, right? Who thinks that's fair? Somebody's got to pay. It's basically either they pay or we all pay. So, causation is not necessarily required. And I'll try and get into that a little bit later because that's a complicated issue. You cannot contract away your CERCLA liability. So if you own a piece of property that you know is contaminated and you sell it to Acme Industries, you can have an indemnification provision in there that says Acme Industries is responsible for all environmental cleanup costs. EPA doesn't care. DOJ doesn't care. They're going to come after you. You can sue under that indemnification clause, but for folks that may be advising clients in the future, indemnification clauses are great if the company is still there and has the resources to cover the indemnity. If I sell my property to Acme Industries and I have an indemnification clause and they go bankrupt, I'm on the hook. The indemnity is worthless. So, 107 is the part of CERCLA that kind of establishes liability. 113, which we're going to talk about in a minute, gives some private party causes of action to reclaim money from other liable parties. Under 107, you can be liable if there's been a release or a threatened release of a hazardous substance from a facility, and PRPs are liable for costs of response incurred by by the United States, a state, Indian tribe, or any other person. And that last phrase has been the subject of quite a bit of litigation and a variety of different decisions. And we'll talk about that in a minute. Again, the costs are only reimbursable if they were consistent with the National Contingency Plan. So in 2009, EPA got commitments worth $2.4 billion from private parties for site remediation. So, hazardous substances is broadly defined by reference to RCRA, the Clean Water Act, Clean Air Act, and TSCA. There's a petroleum exclusion, which again is another source of a fair amount of litigation. If you spill oil at a site, you're not liable under CERCLA. If the oil becomes mixed with anything else or has an additive to it, for example, let's say you've got a gasoline product that has MTBE, which I can't, meryl tetralbutyl ethanol alcohol, whatever it is, which loves to migrate in water, just like PERC, dry cleaning fluid, then it's no longer a petroleum product. Another issue that I was looking at recently is tank bottoms. So you've got a tank that you store petroleum in that you use to fire your boilers, and you want to clean it out. So you pump out the petroleum, and there's sludge at the bottom. You take that sludge out, and you put it in a 55-gallon drum, and you send it off to a place that doesn't dispose of it properly, and EPA has to come in and get rid of it. Does that fall under the petroleum exclusion or not? The rule of thumb is if there are constituents in the material that are at a greater concentration or a greater percentage than the petroleum product, then it is. But there's conflicting case law, in particular on this issue of whether tank bottoms per se fall under petroleum exclusion. There's also a municipal solid waste exemption. Otherwise, the mercury thermometer or the lead batteries or whatever have you that you throw in your trash would cause you to be jointly and severally liable for the cleanup at the local landfill. So release or threatened release is pretty clear, I think. There's no minimum quantity threshold, although in other words, if there's 100 companies that sent 100 tons of waste to a site every year for 10 years, and your company sent 1 barrel of something that was hazardous there once, and all the other 100 companies are defunct, you get to pay the whole bill. There's no minimum quantity thresholds. There are certain de micro minimis exceptions that EPA will consider in enforcement, but in essence, it's important to remember that you don't get off just because you only sent a little bit there. A facility is basically whatever you want it to be, and the case law on facilities is ridiculous. We're probably in a facility right now. Potentially responsible parties, I probably should have had this a little bit earlier in my presentation, but they are owners and operators, current and past, generators and arrangers, and we're going to talk a little bit about arranger liability because it's shifting the last couple of years, and transporters. Traditionally, an arranger could have been if there was a broker that worked in the transportation industry and contracted with Acme Industries to take their hazardous wastes and ship it via this transportation company to, the disposal entity. The arranger is liable, and there's a lot of case law that's the easy sense of arranger, over what exactly constitutes an arranger, and some really interesting developments that we'll get to in a minute. Owners and operators, current and past owners of a site are liable. So if the hazardous waste disposal occurred while you own the property. So if Anna owns the property and hazardous waste disposal occurs there, she's liable. If she sells the property to me and I didn't know about the hazardous waste, and I occupy the property for 5 or 6 years, and then sell it to another company, technically I'm liable. There are some policy issues about enforcement in that context, and the inculpable, lack of culpability status because I didn't know about the hazardous waste. And there's provisions now for protecting yourself from that kind of liability, which we'll talk about in a minute. But if you owned a property that was contaminated when you owned it, you're liable under CERCLA. So obviously, any major American company is acquiring property for a variety of reasons, and environmental due diligence is something that more and more consultants are doing the big part of, because a lot of stuff's been figured out and lawyers are kind of just reviewing, but there are still plenty of issues for attorneys to try and figure out. Exempt parties. Some of the amendments to CERCLA that we saw earlier in the presentation involved trying to, again, increase investment in real estate and protect people who were not culpable and that they were not involved in any disposal of hazardous waste. So innocent landowners, they didn't know there was waste and they had no reason to know. We'll talk about that in a little minute. AAI is all appropriate inquiry. Secured creditors. Now, if you have to you loan money to Acme Industries so they can buy a piece of property. Acme Industries goes bankrupt, you need to foreclose on the property. You're now an owner of the property, it's contaminated, you're liable under CERCLA. That's why investment really slowed down. Now, if you take possession of that property merely to protect your security interest, you don't do anything to exacerbate the situation. In other words, you don't move around all the 55-gallon drums that were on the site. You can be protected under CERCLA. There are some other issues to that I'll get into a little bit because in a minute, because it is an active part of what environmental attorneys do in terms of advising clients about CERCLA. Bona fide prospective purchasers, which is a rather cumbersome process for acquiring a brownfield site and getting EPA to say, okay, we're not going to come and get you if you acquire this site that we know is contaminated, dependent on all these conditions, one of which is a windfall lien, meaning if you acquire the property and EPA pays to get it cleaned up, and then you're able to sell the property for twice what you paid for it, EPA is going to have a lien on that profit amount to recover some of their costs. So brownfields was supposed to be this, big deal. In the state of Maryland, we have a voluntary cleanup program, which is how this is primarily implemented through a state program. They don't function very well. They're really cumbersome. You have to really want the property in order to kind of get through the process. Because of the significance of the issue, however, EPA is very concerned about trying to move this along, and there's currently some renewable energy programs that are going to try and facilitate development of brownfield sites where renewable energy facilities are proposed. Major defenses to liability under 107, essentially there are none. They're notoriously difficult. If you sent a hazardous substance to a site, you're liable. These act of God issues, it's interesting. I was asking someone the other day, so if I send 55-gallon drums to a site and they don't leak, they're all nice and new, and the guy stores them outside,
They get
and
struck by
it rains over the course of 10 years, and they corrode and they start leaking, is that an act of God? Well, it's not, because it's reasonably foreseeable. And an act of God, in any context, under American jurisprudence, is something that was basically not reasonably foreseeable. An act of war, an act or omission of a contractually unrelated third party, where the defendant exercised due care and took appropriate caution. So vandalism. You have a facility, you've got your drums nicely stored, there's some secondary containment there in case anything happens. Somebody comes along and starts doing target practice on your drums, and you have a spill. You're not liable for that if you had no reason to know that that person was going to come out there, you took appropriate precautions, you had fencing up. So this is the defense where there has been some success, but not that much. So I mentioned that 107 kind of sets the framework for who's liable under CERCLA. Owners and operators, generators, arrangers. 107 is what gives EPA the authority to come in and say, you got to clean up this site, or we can sue you and get our money back. This is where joint and several liability is possible. The statute of limitations is 3 years after completion of a removal action. So we talked about removal actions is where you just go and you get the drums and you leave. You've got 3 years from that date that you left to file an action, unless there's the subsequent remedial action, and then you get the 6 years basically from the initiation of the remedial action. And surprise, there's been a lot of litigation about what exactly constitutes the initiation or remedial action. EPA, if you read some of these, EPA and state agencies have reports on big CERCLA sites on their websites. It is very typical for EPA to come to a site, look around, maybe take some drums away, and then forget about it, and then come back a few years later and do some groundwater monitoring, and then leave again, and then come back. And so what's initiation of remedial action can be very contentious, especially if your client's position is, well, they were doing that 20 years ago, why are they coming after me now? Contribution actions under 113 are where a private party, Acme Industries, has to clean up a site. Let's say EPA has sued them and they've had to spend money, they've incurred costs cleaning up a site, and now they want to go after, Baker Industries, and I just made that name up. If anybody on the line is associated with Baker Industries, I apologize. This came after Acme. They can sue Baker for contribution. Contribution is not jointly and severally liable, obviously, because you're getting, you're not able to get from Baker, all of your costs back. The statute directs the decision maker to use equitable factors in apportioning liability. A big issue for the past 30 years in CERCLA is when a private party can sue under 107 and when a private party has to sue only under 113. And given our time, I'm going to probably roll through this pretty quickly and not give you a very adequate explanation. Essentially, initially there was 107, 113 didn't exist. So under 107, you've got joint and several liability. So if Acme Industries has to pay to clean up a site, can they then go sue Baker and get 100% of their money back? Well, the courts basically made it up as they went along, and depending on what your circuit you looked at, it was either a 107 action that was handled according to the mechanics of 113, or they were only allowed a 113 action, and if the complaint only alleged a 107 action, depending on the judge and his mood that day, they were or were not allowed to amend their complaint to include a 113 action, and so it was a mess, a boondoggle, a boon, I should say, for attorneys, but a really confusing state of affairs. Just to avoid the morass of what we're about to get into, because I'm just going to click through it and let you guys, look at these slides on your own if you're interested in this issue. Essentially, the current trend today is that if you're a potentially responsible party, you need to sue under 113. And there are courts that are going to allow you still to sue under 107, but they're not going to allow you joint and several liability. They're going to apply those contribution, equitable allocation framework. And the reason for that is because otherwise you kind of defeat the protections that are offered in 113 for parties that have already settled their liability with the federal government. You don't want somebody saying to EPA, oh, okay, I'm going to settle with you and I'll pay this amount, we agreed that's fair, and then a party who's not been participatory in the process comes in and sues you because they then have to pay costs. In order to protect and to incentivize parties to negotiate and enter into agreements, 113 has certain protections. So basically, some courts will still allow you to sue under 107 but they'll apply the equitable factors of 113. They won't apply joint and several liability. And obviously an equitable factor is you've paid, you've settled up your liability. I'm not going to let this company take advantage of you. I had to stick this in someplace. I'm sticking it in here because 107 is the federal enforcement statute before we get a little bit into 113. Natural resource damages are a hot issue. Anybody who's working at a federal agency right now has probably had some association with this issue. Obviously, in the BP spill, there's a lot going on with natural resources. Essentially, there are provisions in federal law that allow the federal government or trustees, which can be an Indian tribe or can be a state agency, to recover damages for injuries to natural resources. So that could be contaminated groundwater. The groundwater is contaminated. We can't use it for drinking water. You can collect damages for that. You can collect damages for fish kills, which is what's on here. Seabirds and the like. There is a trend to try and collect damages for ecosystem service reductions. So if you have a floodplain that has somehow been incapacitated, someone might come and try and get damages for that. It's a bit of a murky area. An important issue to note on natural resource damages, I can't figure it out, because natural resource damages are intended to cover the costs after there's been a cleanup. So there's been a cleanup, we've cleaned up the site, but it's resulted in these damages to the natural resources that weren't compensated by virtue of recovering costs spent on the cleanup. There's a 3-year statute of limitations on natural resource damages for non-NPL sites. NPL sites are those worst of the worst sites. It begins to run on the date of discovery of the loss, and it's understanding that it's connected to the release in question. That will typically run if there's going to be a remedial action long before the remedial action has taken place. There's been some litigation about when a trustee is on notice that there's actually been a damage, but there's provisions in CERCLA that require EPA to notify state and federal agencies or trustees of damage. So if you're looking at a natural resource claim and it's not an NPL site, there's a good likelihood that you're going to have a statute of limitations argument. If it's an NPL site, it's 3 years from the date of completion of the remedial action, and you're going to be less likely to make that argument. So, given our time, I'm not going to go into the distinctions between 107 and 113 in depth. I kind of covered it. And I'll just move on, because I could go on for days and days, and you all do not want me to do that. A ranger liability I'm going to go into a little bit, and apportionment. The picture on the right is a collision between a train and one of these truck carriers that was carrying a vehicle on its upper level. So you can see the sales sticker in the window.
No humans were harmed.
No humans were harmed in the making of this presentation. And I put that picture there because Burlington Northern and Santa Fe Railroad was a case that the Supreme Court decided in 2009 and has had some interesting impacts. A ranger liability used to be pretty broad. If you had kind of any connection with the spill, you are with the disposal of hazardous waste, you were going to be liable. But now, a ranger liabilities have been interpreted by the Supreme Court to require some intent to dispose of the waste. In this case, in Burlington Northern, it was a railroad yard that was adjacent to a chemical processing facility. There were several parties involved. I think it was Shell was shipping chemicals to this facility to be used by the adjacent facility, and there was some leakage from the train cars. There were different parcels at this site. And the argument was that Shell knew there was going to be some, inadvertent disposal of these wastes, and therefore, because they knew that there was going to be disposal of waste, they should be liable. Well, the Supreme Court said, no, you need to intend. You need to your purpose needs to be that you're getting rid of this stuff. So, in Celanese Corp., which came out of Texas, there was a backhoe operator that was working on a site years ago, and the backhoe operator hit this methanol pipeline. They knew they hit it. They filled it back in, and they went away. It was undisputed that the company knew that they hit this pipeline. Years later, this methanol's leaked throughout the soil. There's a big cleanup action, and Celanese Corp. Wants to go after the construction company and say, you guys are liable because you arranged for this disposal. And the Supreme Court just denied cert in this case, which is not uncommon these days when the Supreme Court takes like 5 cases a year. But they said that the Fifth Circuit said that, regardless of the fact that they knew that they may have damaged the pipe and that there may have been a leak, and it sounds like what happened was, and facts are always important, the operator hit the pipe but didn't puncture it, didn't cause a leak, but the damage to the pipe caused corrosion, which then caused the leak. So the Fifth Circuit said that the backhoe operator was not liable. and that therefore Celanese was on the hook for its share, a significant share of the damages. In another interesting case that is potentially going to have enormous ramifications for localities and municipalities around the country, a Washington state judge allowed the U.S. government to sue Washington State Department of Transportation for, and I said I was a poop lawyer, so this is what I do, the stormwater system, which isn't poop, I guess, but it's not the sewage system, it's the stormwater system in this area was directed across some contaminated property and into an area around Tacoma, a port area that is now contaminated with all kinds of stuff. And the U.S. government said, well, Washington State set up all this stormwater infrastructure which transmitted the waste into the water, and so therefore they're responsible as an arranger. And in 2010, which is the first case cite up here, the court rejected summary judgment claims and said that claim could go forth. And then in March, ruling from the bench, the judge said that the Department of Transportation was liable financially for the cleanup, or part of the cleanup. There's another recent case actually that held exactly opposite. I think it's a main case. Bangor City sewer system was caught up in the same thing, and the judge said no. So that's a ranger. Burlington Northern also has some important things to say about apportionment. We talked before about joint and several liability. As I mentioned early on, CERCLA, two things you see in CERCLA are that it's a mess and that it's based on common law principles of liability. Under common law principles of liability, you can apportion liability even where it's joint and several. So classically, if you have two tortfeasors that cause injuries to another, that person can claim joint and several liability if both parties were negligent and you can't divide the harm. If you can divide the harm, if I can show I just broke her arm, he broke her leg, and that only cost, whatever it costs, and this costs more, if you can divide the harm, you can apportion the damages. Historically, under CERCLA, there had been some cases, more recently in the 90s and more recently, that allowed some allocation, some apportionment, but traditionally it was just not even considered, really. Burlington Northern, the judge in that case, decided basically on his own. Neither party had submitted arguments on this. He made up his own apportionment and said, well, I'm only going to require this entity to be liable for this amount of the cost because I worked these calculations and that's what I figured out. That was upheld. The Supreme Court said if there's a reasonable basis for apportionment, you can do that. Now, it hasn't fared very well in most cases, partly because it's very difficult to divide damages or divide the injury at most CERCLA sites. But it's going to be an issue that's going to continue to come. And there was a case recently, I think it's this Ashley 2 case, where the judge said a rough, what was this term? I can't think of it. A rough calculation that has a reasonable basis is enough. But in that particular case, I think this was at a preliminary motion stage, said that they hadn't demonstrated it. So we're running out of time. I'm going to talk a little bit about risk because that's a lot of what I do in relation to CERCLA. I mentioned all appropriate inquiry. Any company of any size that's acquiring any piece of property in this country should be conducting all appropriate inquiry. There are statutory provisions that say, and this is often misunderstood, I talk to real estate lawyers all the time, you do all appropriate inquiry on a site, you examine the site to find out if there's any contamination there or not. If you discover contaminations there, your decisions are to go the other way or to enter into some cleanup process. Doing all appropriate inquiry doesn't somehow exempt you. You can't do all appropriate inquiry, find out if site's contaminated, buy it anyway, and then say, well, I'm not liable. The whole point is that you avoid acquiring properties that are going to have liability associated with cleanup costs. I talked about the lender liability rule. Given our time, I won't go into it. There's some interesting issues there, including participation in management. If you foreclose on a property because of whatever reason, you can't actively participate in management. And this is a very murky area that's going to continue to be evolve as brownfields development becomes more of a reality. So managing CERCLA liability, you can try and transfer your risks. Doesn't work very well. CERCLA has been relatively successful, depending on who you ask. There's been a number of sites that have been cleaned up. Litigation costs have been extraordinary and probably not very efficient in many regards, but at least it creates jobs for lawyers. So here's a couple of sites that have been cleaned up. What did we miss? Quite a bit. General Electric v. Jackson was a case that was just denied cert by the Supreme Court. That held General Electric has mounted several constitutional claims against CERCLA over the years. One of them regards unilateral administrative orders, which allow EPA to direct a company to clean up the site. The company doesn't have to. They could ignore the order, but EPA can delay enforcement and can ask for treble damages. So let's say they order you to do something, you don't do it, 6 years later, they say, okay, now we're coming to get you because you didn't do our order, and they've got 6 years worth of daily accruing damages times 3. General Electric thought there were some due process issues. The DC Circuit disagreed. Judge Tatel wrote an opinion that describes the options open to General Electric to protect itself or eliminate its liability. Preemption of state laws, another murky issue. If anybody's looking for a law review article, this is a good one. CERCLA has several provisions that say state law is not preempted, but in practice, yeah, it usually is, because there's actual conflict, so it's conflict preemption. But there's been a few cases, particularly against people that are not necessarily potentially liable under CERCLA, like a secured lender. They may be subject to state common law claims if they own property that's contaminated, even though they can't be gotten under CERCLA. Otherwise, it's considered, you can't go to the well twice, basically. So there's some resources, and we have about 5 minutes for questions, if anybody has questions. Welcome. That's the end of Mr. Toad's Wild Ride. Are there any questions? Yes, sir.
Question about framework for successor corporation, whether that is, if there is any framework for any statute or if that's just common law generally as well for successor corporation liability.
Successor corporation liability is dependent on a variety of factors, including whether there was a pre-existing parent-sub relationship, whether you can pierce the corporate veil, and basically what the factual circumstance is with the successor corporation. But essentially, to answer your question, is you're liable. So you'll often see that as there's a merger or an acquisition, and that's when I say environmental due diligence. That's what we do. We go and look at the various properties, look at the issues there, decide whether the risk is worth the benefit to the client.